Hi everyone, my name is Evan Brown and I'll be talking about the Ginsberg v. New York State trial. Sam Ginsberg violated the 484-H of the New York Penal Code. This makes it illegal to sell to a minor under the age of 17 a picture showing nudity. The appellate term of the Supreme Court affirmed the conviction and also denied the appeal. United States Supreme Court case U.S. 629 in 1968 ruled that the material that is not obscene may nonetheless be harmful for children, and its marketing may be regulated. Sam Ginsberg operated a stationery store and was convicted of selling a girly magazine to a 16-year-old minor. New York statute states that depictions of female nudity are harmful to persons under the age of 17 if 1. They appeal predominantly to the prurient, shameful, and morbid interest of minors. 2. Were patently offensive to prevailing standards in the adult community as a whole with respect to what was suitable material for minors. And 3. Were utterly without redeeming social importance to minors. The court found that it was within the state's power to protect minors even if the material is not deemed obscene to adults. Ginsberg and his lawyer decided not to challenge the conviction. However, they would go on the offensive and challenge the New York State statute. His lawyer stated that Ginsberg was convicted without proof of fault. There was no claim that Ginsberg deliberately calculated or sought to induce children to buy obscene material. Ginsberg would also argue that his conviction was a serious invasion of freedom, and there was no proof that he pushed the minor to purchase the magazine. Also, that there was no statement on whether the material was obscene or not for a minor to view. The case is unethical because Ginsberg was aware of the New York State law, but sold the magazine to a kid he knew was under the age of 17 anyway. He knew this was illegal, but decided to make the sale anyway, despite knowing he may get caught. Almost 50 years later, the argument over what is or what isn't obscene is still debated and will continue to change as society changes in its views. While print media is slowly declining in circulation, online media is taking over as society's main source of news and entertainment. Access to the internet by minors undermines the relevance of this case because they can lie about their age. Justice Fortas dissented from the majority, and he argued that the court did not clarify what was obscene for a minor to view or buy. The court also failed to determine what was acceptable for persons over the age of 17 to view. Ginsberg's lawyer did not argue about this, so the courts did not address this issue during the case. The court also ruled that a state may convict a luncheonette operator of a crime because a 16-year-old boy maliciously and designatedly paid for a girly magazine which are not obscene. The court ruling for the United States Supreme Court said that it has the liberty to protect minors regardless if the act in question is obscene or not. The court never deemed what was suitable content for either minors or persons of legal age to view or buy. Thank you.